joining us from across the region, representing civil society organizations, affected communities, legal practitioners, academia, national human rights institutions, and stakeholders committed to advancing corporate accountability and the protection of human rights. The relationship between business activities and human rights continues to be one of the most pressing issues of our time. While business enterprises can contribute significantly to economic development and social progress, their operations can also significantly result in adverse human rights impacts if appropriate safeguards, accountability mechanisms, and remedies are not in place. The discussions surrounding a binding treaty present an important opportunity to strengthen international standards, enhance access to justice for affected individuals and communities, and address governance gaps that allow human rights abuses linked to business activities to persist. Today's webinar seeks to provide a platform for regional dialogue, knowledge sharing, and reflections on the current status of treaty negotiations, their implications for our region, and opportunities for meaningful engagement by stakeholders. We hope that the discussion will contribute to a deeper understanding of the processes and support informed regional participation in the development of robust and effective international framework. We encourage active engagement throughout the session and look forward to constructive, insightful discussion. So I'm going to introduce the speakers. I'm Philia Mwaje from Lawyers for Human Rights, and I will be the moderator of the panel discussion today. We have Ntlagani Potwala from Lawyers for Human Rights, who will be discussing demystifying the binding treaty and its role in an African context. We have Ariella Sher from Open Secrets, who will be discussing the rationale for a binding treaty, given its limitations of international law, given the limitations of the international law frameworks. And we also have Matapelo Diale from Makua, who will be discussing the relevance of the binding treaty for communities in the extractive landscape and how the binding treaty could contribute to communities. And then after they speak, our three panelists speak, we'll have a question and answer session from approximately 10:55 to 11:25, where the participants in the panel will be able to basically contribute comments as well as questions to the discussion. But also note that throughout the session, you are welcome to throw your contributions into the chat, just so that you don't forget. But also we ask that you indicate if you do not consent to us uploading this recording to YouTube at a later stage, because we are going to be recording the session. If any of you object, kindly do type in the chat or note your objection right now. If there are no objections, we will then proceed. I will be putting the agenda in the chat so that everyone can see it and be able to follow appropriately. Yes, over then to Ntlagani Potwala, our first speaker of the morning. Ntlagani Po, over to you. Thank you.
Thank you so much, Comrade Philia. I'm just going to share my screen so I can share the presentation with all our participants. Okay. Thank you again, Philia. And I'd like to say good morning, first and foremost, to all of our colleagues inside and outside the profession, participants from communities. Good morning, all of you. Now, as introduced, comrades, my name is Nhlakani Twala, a legal intern here with the team in the Environmental Rights Program. And for my session on this pre-webinar, I will be demystifying the binding treaty and its role in an African context. And really, what we emphasize with this webinar is for it to break down complicated concepts so that we can all participate meaningfully ahead of our Indaba on the 24th and the 25th. And also, I just want to place communities at the center of the vision that we have for this pre-Indaba. And it really is so that we can all meaningfully participate, but also I hope it also raises the necessity to communities and activists on the ground for the need to participate in this webinar meaningfully and to bring perspectives and experiences of communities at the center of the discussions that we are going to be having. Now, very briefly to run you through the contents of my presentation. I will touch on the background of the binding treaty, how it came about and when it came about. And here we will see that Africa and African states really were at the forefront of supporting the introduction of a binding treaty. And this will place emphasis on why it is important for South African and African states to participate in the binding treaty. And we will break that down as well. And then just to go through the concepts, we have to explain what a treaty is. And so we will go through that as well as the second point. And we will explain also the binding nature of a treaty and the related concepts. So what does it mean that the treaty is binding as opposed maybe to voluntary? So we are going to touch on that as well. And I'm just going to make use of examples between a binding treaty on business and human rights and compare it with the UN guiding principles on business and human rights. And I think that will help clarify the binding nature of a treaty. And then we are going to go into multinational companies in the African context, and then we will close with the necessity of a binding treaty. All right. Just to give a bit of a background briefly, in June 2014, the UN Human Rights Council took steps to develop an internationally legally binding instrument to regulate the activities of transnational corporations. Now, sorry, I lost my presentation there. Excuse me. All right, sorry about that. Now, you will notice that there is the inclusion in that background of transnational corporations. And this word is going to come up, this term is going to come up quite often in this presentation, as well as the presentations that are going to follow. And we are going to use them interchangeably, transnational corporations and multinational corporations. And so these are big businesses that have operational facilities all over the world, and they also deliver their products and services worldwide. And so the reason why the UN Human Rights Council saw it fit to introduce the binding treaty and to invite states to participate in it is necessitated by the nature of how these transnational corporations operate, how they carry out their operations and use African states as their extractive center. And leave behind a lot of environmental degradation. They wipe out the socio-economic fabric and potential and future earning potential of people in the communities. And we will also see examples of cases such as these, and we are going to use at a later stage in the presentation, the Children of Kabwe case to bring these issues to the forefront. Now, the internationally legally binding instrument is currently referred as the UN Binding Treaty on Business and Human Rights. And out of the 20 countries that voted in support of the resolution, 10 were African states. Now, excuse me, the overwhelming African response to the resolution emphasized the necessity and commitment of African states to fighting corporate impunity. And I think this is an important point to note, that the inclusion of African states in this binding treaty is important because we in the world are the most affected. So if you look at how these transnational corporations are structured and how they operate, African states, Zambia, Botswana, South Africa, and others are the extractive center, the DRC, which is really riddled with a lot of human rights violations and concerns that reverberate all over the world and affect the everyday lives of ordinary citizens living in that region. And so it is important for African states to be at the forefront of contributing to the resolution, because we are the most affected, and the bulk of the negative effects of mining operations, agricultural operations, agro-processing operations accumulate themselves in the African region, as well as other global south regions in Latin America and so forth. Now, what is a treaty? Sorry. So a treaty is a legally binding agreement between states that establishes rights and obligations governed by international law. A state will sign a treaty and voluntarily accept obligations under international law, and international law institutions monitor compliance to resolve disputes that may arise after the treaty has been signed and ratified. And we will explain what I mean by ratification at a later stage in this presentation. But I think to simplify, we can think of a treaty in terms of a contract. But instead of individuals, it is an agreement between countries. Now, when a state signs or ratifies a treaty, the official adoption of a treaty, the agreement that says we will agree to the terms of this resolution, that agreement is called a ratification. And so once a state has ratified the treaty, it voluntarily accepts the legally binding obligations under international law. And international institutions help to monitor compliance in a similar way that in a private contract, courts and regulators act as mediators to help monitor compliance to the obligations written in a contract. But these are between countries. And the earliest example we have of a treaty is the Treaty of Westphalia, which is a peace treaty between states that says we will no longer engage in conflict, and thereby reducing the negative effects on both the states that were engaging in conflict at the time. But in this case, it is a binding treaty on business and human rights. And we are going to see what that means in the next session, which is the next section, excuse me, which is the binding nature of a treaty. Now, what this means is that a treaty is legally enforceable, first and foremost. The term binding means it is legally enforceable, and states are legally obliged to uphold the terms of a treaty. And a failure to uphold or enforce a treaty can have consequences. So, because it is something that you have voluntarily accept and obliged yourself to uphold, there are consequences that can accrue on the part of the person who breaks the treaty, the state that breaks the treaty. And most often, the consequences are political. It is you lose international trust, you lose political leverage in whatever trade deals that you might have with other states, and you stand in um, the likelihood of facing sanctions, which really complicate and frustrate, I would say, the economic environment of a state. So these are real consequences that can accrue on the part of a state that breaks a binding treaty that they have volunteered to uphold. And it is different from what is called the UN Guiding Principles on Business and Human Rights, because and maybe to explain what the UNGPs are. They are not on my slides, excuse me for that, but it has three pillars essentially. It is a state duty to protect human rights, corporate responsibility to respect human rights, and access to remedy in case violations do happen. But there are strong criticisms of UNGPs because they are of a voluntary nature. Um, so, international law, in terms of a binding treaty, it develops legal obligations. But UNGPs are soft laws. They are soft law, rather. They fall into that category of what legal professionals describe as soft law. And they only serve a persuasive nature and not a legally enforceable one. So now, remember that a treaty applies after a state signs or accepts it, but UNGPs are voluntary, and this leaves gaps in terms of how implemented. It leaves gaps in terms of implementation, and it is not. It is seen as, I guess, not reliable, and there's lots of commentary among legal professionals and academia. Sorry, I'm just. Yes, Philia?
Just 5 minutes, by the way.
Oh, 5 minutes remaining is what? Okay, thank you.
You're muted.
Thanks, Carl. So the binding nature of a treaty and related concepts. You will remember that at an earlier in this presentation, I mentioned ratification. and that is the formal agreement to accept the binding obligations of a treaty. But there are, however, reservations that a country might have into signing certain provisions. So there is that provision for countries to not accept each and every binding provision if it interferes with their domestic laws or their vision for the country. For instance, South Africa envisions that the binding treaty would apply only to multinational companies and not to small and medium enterprises, because this is the bread and butter of the citizens, and you do not want to introduce obligations that may frustrate that environment. All right. But this process does not nullify the efficacy of a treaty. It can still carry meaning beyond articles that the state has ratified. And transnational corporations in the African context. And this is a look really at the structure and operations of multinational companies, the power that they have, and how this contributes to frustrating the environment, or rather, how they frustrate access to remedy of the communities and the citizens of the places in which they operate. And it also gives emphasis as to why a binding treaty is important in this regard. So the structure of multinational corporations is such that it operates in different territories and different jurisdictions. And so when a harm occurs in a, let's say, Zambia, in the case of the children of Kabwe, um, the complication that arose when the community tried to access remedy is that one, Zambia does not have, let me say, it does not allow class action lawsuits in their legal system. And so the case had to go to South Africa, and South Africa was the jurisdiction that was chosen in the Children of Kabwe because Anglo America, which was operating in Zimbabwe in Zambia, excuse me, during those years, was headquartered in South Africa. And so this is how they sort of overcame the challenge of jurisdiction. Um, However, there's also another complication of how powerful multinational corporations are. And you could think about it in terms of the valuation of these companies and how much profits they have, and how these profits and their valuation often exceeds the GDP of most countries. And so this gives them a lot of unmonitored power to influence policy, and drive the direction and priorities of a country in a way that frustrates the environment, because most of these countries have instability in terms of their politics, and the governance is very weak in some of the countries in which they operate. And so they have a lot of power. Um, all right. Lastly, just to close, the, the binding treaty on business and human rights is very important in the African context, because um, a binding treaty becomes necessary because it addresses the gaps that we have just mentioned. It answers the question around jurisdiction, because it introduces what it is called extraterritorial jurisdiction. It strengthens state obligations to regulate multinational corporations. It covers the gaps in countries with weak governance, political instability, and lack of judicial independence. And it also introduces human rights due diligence. And in the case of South Africa, we do have environmental laws in terms of NEMA, the National Environmental Management Act, but these are not human rights due diligence that we have in South Africa. And so we would benefit greatly from due diligence being examined and judged on a human rights angles and the harms that transnational corporations often inflict on communities can be viewed as human harms, human rights harms, rather. Yes. So I think that just about covers it for my portion of the presentation. Thank you very much. Over to you, Philia.
Thank you for that, Nhlakanipho. I think you did a brilliant job of grounding the conversation for us, and introducing us to the basics of what it would mean for a treaty to be binding on transnational corporations, especially when it comes to, the example you gave of the Kabwe case and clarifying some of the issues there, especially when it comes to issues of massive profits that companies do have, the jurisdictions that are cross-border, and the need for human rights due diligence. So thank you for that. I'm going to now hand over to Ariella Share, who will introduce us to the concepts of a rationale for a binding treaty given the limitations of international law frameworks. And yeah, over to you, Ariella. I'm just going to ask Nhlakanipho to kindly thema the presentation, please. Ntlaga, could you please, thank you so much. Over to you, Ariella.
Thanks so much, Philia, and thanks so much to the organizers for inviting me to speak. As Philia said, I'm going to speak to a bit of a quick lesson on international law, to discuss what the limitations of international law are, and why there's therefore a rationale for a binding treaty in the context that the previous speaker has explained. So just a little bit of background. The general structure of international law looks at states as the main subjects and uses the law to regulate interstate disputes. It outlines and enforces states' rights and obligations. It does recognize that individuals have rights, but the obligation is on the states to respect those rights. And there's no recognition of anything but in between the state and the individual. Those are really the entities that the international law framework provides for. And as a result, the realization and protection of human rights has been the sole responsibility of the state. International law places clear obligations on states to protect, respect, and fulfill the human rights of all those living within their borders. So, as I said, at its fundamental level, international law does not structurally accommodate any actors that sit between states and individuals. But in the late 20th century, with increased industrialization and globalization, the overwhelming power, both political power and financial power, of corporations became impossible for international law to ignore. Companies obviously did not emerge at that time. The notion of a corporate entity has been around for hundreds of years, and corporates were heavily implicated in, if not in some instances, driving both slavery and colonialism. Multinational corporations can wield more power than states themselves, and we know that their operations have a clear and direct impact on human rights across the world. So, by the late 20th century, it really came to a point where international law could not continue to pretend that this is not true. So this is the time at which the concept of business and human rights became an emerging area in international law. Broadly, business and human rights reflects and builds on the notion that corporations are required, at the very least, to respect, so not interfere with internationally recognized human rights wherever they operate, and that they should be held accountable for violations they commit in the course of their operations. So, and again, as the previous speaker has reflected on, the first major step in the business and human rights movement was in 2011, where the United Nations Human Rights Council acknowledged this emerging need to recognize the place and the role of corporations in international law. And they endorsed the United Nations Guiding Principles on Business and Human Rights, the UNGPs. The guiding principles follow the respect, protect, and fulfill framework of international human rights law, but they recognize that corporations assume only the respect and protect pillars, in that businesses should not infringe on the human rights of others, so that's respect, and businesses should address any direct adverse impacts of their operations, which is the protect pillar. States alone, in terms of the UNGPs, retain the obligation to fulfill, being to actively provide for human rights. However, while the guiding principles are widely endorsed by many states and even many transnational corporations themselves, and they're increasingly invoked by courts seeking to hold corporations accountable for their violations, they are non-binding soft law, and thus they're still unenforceable. They're not binding, and that's a major issue with them. But it was a really big first step, and they're widely recognized as reflecting the law as it exists today. The same non-binding nature can be said of the United Nations Global Compact, which is a voluntary pact that encourages companies to promote human rights and fair labor practices, protect the environment, and fight corruption. But again, it's voluntary, it's non-binding. So it just doesn't meet the standard that international law and corporate violations now requires. And more recently, the EU has adopted what it calls its Corporate Sustainability Due Diligence Directive, the CSDDD, which compels the region's largest corporations to undertake constant due diligence measures to ensure that they're not violating human rights in their operations across their supply chains. Unfortunately, however, the direct obligation that is placed on companies by the CSDDD is to meet the due diligence requirement. That is their obligation. Their obligation is not to protect human rights more directly. So a violation of the CSDDD is a failure to conduct due diligence. And so effectively a violation of human rights still goes unpunished so long as the corporation can show that it undertook its due diligence requirements. The scope of the CSDDD is also limited both only to those companies that are headquartered in the EU region and also to only the very biggest companies in that region. So ultimately, the CSDDD has a very narrow impact. It does not apply internationally, and its narrow impact is really a problem in the context of widespread corporate human rights violations. So the unenforceable or otherwise limited nature of these existing business and human rights mechanisms has resulted in a big gap between the underlying need to regulate corporate activity and the practical application of these standards. Many of the world's largest corporations if you look on their websites and their sustainability documents, they'll proudly espouse their commitment to human rights through publicly endorsing the UNGPs or the Global Compact. But obviously, we know if we look at their operations and their conduct throughout their supply chains, it tells a different story. Corporations with well-known adverse human rights records have told us that they endorse the UN guiding principles. Examples of this include MTN and Anglo American. So clearly, the system is not working in the way that we need it to, because corporations are able to both endorse these non-binding standards, but also continue violating human rights. This gap between what the principles espouse and what the actual operations look like is not an accident. Transnational corporations, through international business organizations such as the International Chamber of Commerce and the International Organization of Employers, have openly and very successfully used their political reach and resources to advocate for the soft law, non-binding approach to business and human rights principles. And this includes loudly rejecting the need for a binding treaty. At the annual negotiations for the binding treaty, you'll always see the Organization of Employers sitting there. They're very well, they're very articulate. They've got what sounds like very compelling arguments, but if you listen, they're always against the nature of a binding treaty. So this has meant ultimately that the actions of transnational corporations are primarily regulated by national legal systems rather than international law. And the problem there is that the protection of human rights really varies between domestic jurisdictions. This creates an asymmetrical, unbalanced system in which transnational corporations' accountability differs depending on where they operate, where they're headquartered, which jurisdiction the victims try to achieve remedies in. But despite these issues, what is good news is that over recent decades, we've seen various landmark cases tackling the impunity of transnational corporations for human rights violations across the world. Some examples include the Royal Dutch Shell case in the Netherlands, and also, as the previous speaker mentioned, the Kabwe case in South African courts. But almost all of these cases have been litigated in global north jurisdictions, whereas the violations that they're dealing with are committed in the global south. And this is noteworthy for many reasons, including that the corporation's money, and thus the remedies that's available to the victims, is most often held in the global north. So it means that justice lies very far from the lived realities, and thus the access of affected persons and communities. And ultimately, this negates their ability to pursue their rights and achieve remedies for the violations. It also means that different legal standards across the different domestic jurisdictions, and thus differing opportunities for justice, exist for victims, depending on which jurisdiction hosts the offending company. This is neither fair nor is it sustainable when we know that violations are so widespread across the globe. Now, the power and reach of corporations that we've discussed and their continuing violation of human rights across their operations demands that we recognize and adopt one prevailing and binding system of regulation for companies. That one system must provide victims with a uniform protection and access to remedies. So again, one system for all victims, for all companies, regardless of where the victims or the offending company is situated. That is the primary rationale for and mandate of this binding treaty process. And I'm sure the next speaker will build on that. Thank you.
Thank you so much, Ariella. I think what really spoke to me is that there are so many voluntary mechanisms through which, multinational corporations are meant to show that they're abiding by international standards. However, this just shows the gap and the need for a binding treaty. So I'm going to hand over to Matapelo Diale to really show us or the relevance of the binding treaty for communities. Because I think that is where the need for a binding treaty really comes through. Matapelo, please come through with your intervention. You're muted, leadership.
Sorry about that. Good morning. Like Comrade Filia said, my name is Matapelo Diale. I am from Makua. I'm Makua National Secretary. My focus is basically going to be on explaining the importance of the binding treaty in a layman's term, in terms of communities and trying to ensure that communities understand the importance of binding treaty and how it's going to benefit us as communities. In most cases, across mining communities, extractive regions, you find communities experiencing a lot of negative impacts. Mining communities. I've never been to a mining community that is well developed, that is progressive. When you go into mining community space, you find communities that are displaced. You find communities that are stateless. You find unemployment rate is extremely high. Water pollution, air pollution. The areas are not developed at all. The communities, mining communities, are basically the poorest of the poor. They are marginalized. And there isn't a mining company that mines in an area that is modernized, that is urban. All mining activities are closer to communities that are marginalized, communities that are undeveloped, communities that are poor. So that's why the treaty is important for communities, because the mining space affect the displacement of women and children. So it's conditions that are very poor, and all these mining companies, they are not being held accountable. Holding them accountable, it's not an easy process. Hence, it's great to have a platform, a binding treaty, a process, a binding treaty that would really speak for the ills in our society, and for the treaty process to also make sense is to bring in the directly affected people who are the ordinary members within mining communities. So that's basically what I'll be touching based on what the communities are going through and how, as communities, we can take advantage of this binding treaty process. So there are laws across countries, laws that regulate mining activities. But more often, these laws are just vague. They are not laws that really hold these mining companies accountable, where communities are able to litigate and ensure that mining companies assist, or mining companies do what is right. In South Africa, we've got an SLP process, a social labor plan, that it's said to be it's legislative, it's within an act. But there is no law that says if a mining company within 5 years it has not done what it said it would do, what then happens to the mining companies. We see mining companies continue beyond the 5 years that they said. You find communities where they said they would build a clinic. Let's look at Springbok. where a mining company, it was Afrimed, and then it moved to being Sipaku. Afrimed sorry, I needed to move network. Sorry about that. So you find companies like Sipaku takes over, and Sipaku still does the same thing as Afrimed, and nobody holds them accountable as a company to say this is what was expected from them in terms of SLB processes that's been done. So the binding treaty, it seeks to address such behavior. The binding treaty, in a layman's term, is a process that allows communities like Springbok Ban, displaced communities like Blyforitsert, communities that are forcefully removed from their land, like Stekerwater, to find some form of justice. So that is the easier way of me explaining what a binding treaty is. So it is very important for our communities to understand the binding treaty and be part of the process, binding treaty. Let's look at the current situation that is happening in Green, where a mining company has decided to demolish homes of ex-mine employees. Some of the mine employees are there still awaiting compensation. And a mining company decides to demolish the homes and displace women, children, and the community itself. And no one is holding the mining company accountable. No one is questioning the impact of their action. Let's look at what is happening within the coal sector, where Malahleni communities live in an environment that is hazardous. Yet nothing is being done, and companies continue to change hands to avoid taking responsibility for the ills within our communities. It is those issues in an ordinary human being living in a mining community that communities would want to see being addressed. So for me, that is how important the binding treaty process is. It addresses the ills within our community. Because I think the legal aspect of things, the two presenters already highlighted why the treaty is important in terms of legalities. In terms of an ordinary community, it is important because it seeks to address our ills. It seeks to hold those who are putting us through what we are going through, for them to take responsibility for what we are going through. So that is, for me, the importance of the treaty. women are displaced. We find communities where we are currently going through a process where there are campaigns that seek members, and no one is addressing the core reason why ex-employees from neighboring countries are still within the country. Nobody is addressing that. So through the treaty, we are able to ensure that such things are addressed, and we are able to protect those that contributed to the economy of South Africa. So I think for me, that's in short the importance of a treaty to an ordinary citizen living in a mining community. Thank you very much.
Thank you, Matapelo. I think you've just highlighted us on the environmental and socioeconomic toll that the extractive industry, puts on the shoulders of communities, and some of the reasons why a binding treaty is necessary for communities, as well as, why you kind of spoke to the corporate impunity of transnational corporations, which allows them to get away without accountability in a lot of instances. And I think that's so important in a lot of ways. So now what I'm going to do is open up for a question and answer session. I see that nobody has typed any questions or comments in the chat. So I'm going to just open up for a round of hands. If anybody has any comments, questions, or any, inputs that they would like to share with us. Yeah, you may raise your hands now or type in the chat so that we may note you. Are there any inputs that anyone would like to have? Any comments? Yes, Comrade Martin. You may unmute yourself and come in.
Comrades, a very good morning to each one of you here today. And I must apologize. I came in a little late. I was battling with my logins here. But as I came in, Comrade Ntlaganipo was on the floor, and shortly thereafter it was Comrade Ariella, and then my comrade SG Matapelo. The central theme seems to be around getting these companies to account to the communities that they are doing businesses in. However, it would seem like companies have been managing to find technicalities with regards to issues of jurisdiction to avoid accountability. Secondly, my observation is, as Comrade Matapelo has also alluded to, is that in spite of the fact that there's legislation around social labor plans, there's still some element of impunity from companies in terms of not implementing SLPs. And essentially, this is why we are gathered here this morning, to come up with something that will be legally enforceable, which will be binding and legally enforceable. But my question becomes, how do we do that as a local community? The community that Comrade Matapelo spoke about, the community of Kriel, which has been displaced through demolition of their homes, is a community that is very close to my heart. There's also another community just across the street from where I am, the community of Lesedi, which is also facing displacement and demolition of their homes, as Siriti simply has rendered them powerless. What these companies are doing is they are retrenching each and every one of their permanent employee force, labor force, and then they are calling them back on a contract basis, so that they are finding themselves an ununionized labor force, which does not have a mouthpiece to represent their interests. And as a result, not only are the workers weakened, but also the entire community is weakened. I'll leave it there. But the question is, how do we come up with a binding treaty as a community? Thank you very much.
Thank you for that question, Mr. Martin. Are there any other questions that we can take? Okay. Would any of the panelists like to attend to this question of how do we come up with a binding treaty as a community, especially also on the intervention of, the binding treaty speaking to the question of jurisdiction?
Oh, please go ahead. Okay. But I will attempt one part of the question. And this is because, Comrade Martin, you have raised, I think, a very important issue with the use of examples of what is happening in Lesedi, in Mpumalanga, I'm assuming. So I think from a community perspective, one of the ways that we are achieving this as organizations and partner organizations between LHR and CALS is we have already been to Masakane and noted the concerns around various issues, one of them being the demolition of houses in Lesedi, as well as the worker rights violations that you are mentioning, Comrade Martin, of workers being taken off their permanent contract and being invited back to work as temporary employees. And so one of the interventions that when we gathered and we sat down with these issues and tried to speak to them, or rather think around remedies, is for us to introduce communities to different specialist organizations in the sector. We know that Lesedi has had, I think, engagement with LRC for the housing problem, and it's a continuing remedy, as well as other issues in the area of worker rights. And we ourselves have consulted with workers from Masakane. So I think strengthening the bond between our sector, these organizations, Makua, Lawyers for Human Rights Center for Applied Legal Studies, AIDC, really working as a coalition with communities has seen some positive results, and we know that the wheels of justice turn really slowly, and it can be a frustrating thing. But however, there is that presence when we work together as a coalition. So I think that is just one part of the question, and yeah, I will leave the more technical part for you, Ariella, if that's okay.
Thanks so much, Ifakanipo. And thanks, Martin, for the question. I guess it's to highlight that the move and the movement to get a binding treaty on business and human rights is only one aspect of the fight. You know, pursuing the implementation of social and labor plans at a domestic level is as important. So, you know, for communities to get involved in the binding treaty process, that's the purpose of these webinars and the Indaba, is to really bring the people who are most affected by corporations' human rights violations into the discussion, and to, you know, put them at the front of the discussion and to really lead the process, to hold corporations accountable. In terms of jurisdiction, the way that the treaty would work, and one of the reasons that you know, one of the rationale for an international binding treaty is that it would override the jurisdictional issue because it is international. So every state, you know, you would push your state to sign up to the treaty, and then every state that signs up to it is obliged to comply with the treaty's provisions in their domestic jurisdiction. And at least in the terms of the way that South Africa's law works in our constitution, international law is incorporated into our domestic law. So it overrides that constitutional issue, that jurisdiction issue of having different standards in different domestic jurisdictions.
Thank you for that, Ariella. There's a question in the chat from Paul. The question reads as follows: how will the treaty ensure accountability where states are unwilling or unable to regulate powerful transnational corporations, particularly in African contexts where communities are most affected? Noting the Kabwe case, of course. And I think this also speaks to Ndaganipo's point in his presentation, where there was an indication that sometimes multinational or transnational corporations have, you know, bigger or deeper pockets than states in some contexts. So I don't know who wants to take this question, but I'll repeat it again, or point you towards the chat. But just for the benefit of everybody, how will the treaty ensure accountability where states are unwilling or unable to regulate powerful transnational corporations, particularly in an African context where communities are most affected? Noting the Kabwe case, of course. Nhlakanipho, I think this one is directed at you. Can I direct this one towards you?
Yes, you may. Yes, you may, Comrade Philia. Thank you very much. So I think one of the important things to highlight is the binding nature of the treaty, in response to the question on accountability, and that fortunately it is an international instrument. It's an internationally legally binding instrument that is regulated essentially by international law institutions such as the UN. So the intermediary between states and signatories that have ratified the document are, international law institutions such as the UN. And so where states not willing maybe or unable to regulate powerful transnational corporations, The political implications of it are such that we can have consequences in the form of sanctions. Your consequences may vary, but also it makes us really unpopular on the part of our bargaining power when we have to have trade agreements, which are essential for the economic progress of any country. And so it is in the interest of states to abide by the provisions that they have ratified themselves, and failure to do so does have implications that are both legal and political as well. I'm not sure if this answers the question, but I would welcome any additions that participants can have. Thank you very much.
Thank you, Ntlaga. We have a hand from Pumelele. Can you come in with your intervention, Pumelele?
Good morning, Comrade Filia. Thank you so much for this platform, and thank you to the panelists for their contributions and insights. Very valuable. I think I'd like to share perhaps a comment and then end with my question. I think conversations like this are very, very important, but can also be quite frustrating, especially when you link it to the lived experiences of the communities that tend to be at the forefront of human rights violation. And I think particularly for South Africa, we have, I'll still say it's a recent reminder of what it could potentially look like when we look at the Marikana massacre. We have to remember things like that because these are the frustrations that the communities experience, and may their souls still rest in peace as we continue the fight on platforms such as these. And I think my question then would be, I just want to get a feel from the panelists in that with a binding treaty such as this, how much of an impact or a catalytic effect would it have on the national or domestic laws? Just referring to what Comrade Matapelo mentioned in terms of the SLPs and the 5-year plans, which tends to relate to mining rights, if I'm not mistaken, in terms of when you want to mine in a particular community, they'll say one of the requirements is for you to present us with the SLP, but then there's no enforcement. So there's a lot of national, I'd say, national legislative gaps that could also assist in protecting workers and communities ultimately. So I am just curious about that in terms of this binding treaty. How much of a catalytic effect will it have on maybe amending or reading in certain aspects of law in terms of national law? Thank you so much.
Thank you for your question, Pumelele. Can I give this to you, Ariella?
Sure, thanks so much. So it is one of the kind of micro fights that is happening in the negotiation process, which is that there is, I'm not sure if it's currently there in the draft, but there has been a fight over including a clause that says that any treaty that is ultimately adopted is subject to domestic laws, which means that any domestic laws that currently exist, the treaty would have to, the application of the treaty and implementation of the treaty would have to comply with those laws. And obviously that's something that we as civil society have been fighting against, because the idea of having a binding international standard is that it's an international standard, not that it's an international standard that then is dependent on whatever the domestic standards are. So that's one of the very many fights we're having in the negotiation process. Ultimately, if we're looking for a binding international standard, it can't be subject to domestic standards. because that defeats the whole purpose of the exercise. So hopefully when we do get a final treaty, hopefully it's of the strongest kind we can hope for, and that would include that it's overriding domestic standards.
Thank you so much. Do you still have an intervention, Pumelele?
No, I just wanted to say thank you for that clarity, because I guess if I could speak confidently for a few masses, is that we don't want to find ourselves in that frustration of that there is a beautifully written instrument, which is supposed to in effect support and assist members of the society, but it doesn't, for those very legal loopholes that exist. So it is relieving to hear that the fight is for it not to be subject to national laws where applicable. So thank you for that.
Thank you, thank you. Are there still any burning questions or any other interventions or comments, inputs, questions, anything like that that anybody wants to just jump in quickly with in our last couple of minutes together? Yes, Martin, please come in.
You know, I'm just a little confused here around this concept of a binding treaty. I understand why it is important to have a binding treaty, but my question becomes, how do we generate, how do we produce it? Who produces a binding treaty? Is it affected communities around the world meeting together under one umbrella, bringing to the fore each and everyone's own unique experiences? How is it really been put together? I just need clarity on that one.
So that is exactly what the second webinar is all about. The second webinar will be speaking to the process of getting to a binding treaty. But just a brief snapshot. States are the parties to a treaty process. They so each individual state is supposed to be in a consultative process with its constituency in an effort to formulate a position. And then when they go into negotiations with other states, they have a position already on what are yeses, what are nos for them. And then that's the basis on which they negotiate. And obviously, there are other considerations as well. Um, for example, stakeholders would be civil society. So civil society is composite of NGOs, community organizations, etc., etc. And in that, these moments, the binding Pre-Indaba, etc., we have moments in which we go through consultative processes, and that's why we have the binding Pre-Indaba. We have it so that we can go through a consultative process with communities to find the yeses and the nos with regards to the position of community members on the binding treaty. This has been a process over a bunch of years. This is not the first iteration of this process. It's been an ongoing process, but effectively, this is part of the consultations towards this state consultative process. And in these moments, we have at the binding treaty in Daba, we have a bunch of other stakeholders in the room as well. And it's not just communities that we are with, it's state representatives, etc., who make up the whole body of people that we engage with a view to really ensuring that community voices do make up the portions of the binding treaty in Daba. I mean, the binding treaty, so that the 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 finer details of the binding treaty are really influenced by community voices. Does that make sufficient sense, Mr. Martin?
So far, so good, Comrade Philia. So far, so good, but I guess I'll wait for next week's second session to really get to grips with the machinations around this binding treaty. Maybe the final question would be, what happens where people are not willing to sign and commit? What happens? Are there any punitive measures in that regard? But you said there's going to be political and legal consequences, right? Then what? If a company is as big and massive as Shell, would they really care? Or would they still continue doing their business around the globe? Those are, I don't know. Thank you so much.
I think save that question for next week's webinar, and hopefully we are able to answer it then.
Thank you very much, Ma. Thank you.
Thank you. Thank you for that. Are there any other further interventions? Otherwise, I think we can wrap up the session and thank everyone for their time. It seems there are no other further inputs or interventions. And in closing, I would like to thank the speakers for really, being a part of the session and sharing their knowledge with us, but also for, taking time out of their busy schedules to be here with us. So thank you, Ariella. Thank you, Nhlakanipho, and thank you, Matapelo, for, really doing everything in your power to give us your insights. And then I'd like to thank everyone who took time out of their day to be here with us and share, as well as ask us meaningful questions and engage with us today. It's been a pleasure being here with you. We really appreciate your time. And we look forward to the second session where we'll take you through the journey and what happens when states negotiate the treaty itself. And I think we'll be better able to answer Mr. Martin's questions then. And yeah, I think this has been a very enlightening session on, you know, the binding treaty, at least in its initial formations, and what happens in relation to communities, as well as why it's important for communities as well. So without further ado, I'd like to just thank everybody one last time and wish you everybody a great day forward. Thank you, everybody.